This is University Avenue.
Yep.
I growed up here.
Okay.
You know, Natalie White, she's my girlfriend.
Okay.
She left off. I said, babe, I'm going to get Wendy's and I'm going to go back to work.
That's RAYSHARD Brooks. He was the man who was shot and killed by police in Atlanta, who now one of them faces a murder charge. And that part of the conversation didn't seem like it was that significant when we looked at the body cam footage of his interaction with police before he was shot. But then this happened. Take a look. You've got someone setting fire to the Wendy's that he was at, right? And you've got this suspect picture that they looked at, and they're like, well, who is that? Well, now someone has been arrested as being one of the people accused of setting the fire to the Wendy's, and that's her. Now let's go back to what I played to you, which was RAYSHARD Brooks saying, Natalie White is my girlfriend. The woman they arrested, her name is Natalie White. Now it hasn't been confirmed if it's the same Natalie White, but right before he's shot and killed, he's talking about his girlfriend, Natalie White, and now a woman named Natalie White has been accused of setting fire to the Wendy's that is the focal point of all of what is happening here in Atlanta right now in terms of the discussion. So she was in court for a bond hearing. It was all done on Zoom. Let's take a look. Let's take a listen.
Ms. White, this is your first appearance. You have the right to remain silent. Anything that you say can be used against you in court. You have the right to have an attorney represent you at this hearing, and it appears to the court that you have retained Mr. Drew Finley to represent you in this matter. Is that correct, ma'am? Thumbs up if yes, thank you. All right, I'm going to take a look at your warrant, consider you for bond. I'm looking at a warrant from June the 13th at 125 University Ave, Atlanta, that alleges an arson first degree, and that said accused knowingly damaged by means of fire the Wendy's restaurant located at 125 University Ave, which was insured against damage by fire explosive. All right, I'll find that the warrant establishes probable cause. All right, Mr. Finley.
Recommendation of the state, we would at this time be asking for a signature bond. Your Honor, I've known Ms. White since she's probably 8 or 9 years old. She's from the North Coast community. Although I don't long live there, I've been dedicated to that community for since. So I know her, I know her family, and under their present financial circumstances, her mom's working at a pizza restaurant, and I'm helping them out, but they just don't have the funds to make any bond whatsoever. So I ask again that it be a signature bond. The mom is with me. She reminds me of her sister or godmother is with me. I just can't really bring it forward because of COVID-19, but they all are all situated in my office.
Well, if the option to me, hang on, Mr. Lewis. If what you're saying is it's signature bond or nothing, that doesn't give me much room to work, Mr. Finley.
No, I'm not saying
and I'm willing to consider something, and apparently the DA is too, recognizing that under OCGA 1761E, apparently she does not offend any part of the bond statute. So I would find that a setting of bond is appropriate. In other words, I'm not going to deny bond, okay?
Right. So then I ask that it be reduced as much as this court would be willing to reduce it, given that I'm holding in good faith that I've explored their finances and they are really limited. They do.
Well, so
I'll tell you what, I just want to object to the 20,000. I mean, I don't think.
Well, look.
I object to the $20,000 bond.
Mr. Finley, I think we can find something that fits the situation, because what I'm concerned about is danger to the community, right? And so if there was a lower bond with a house arrest component and a stay off social media component, that may be, since the family is in such dire financial straits, that may be more appropriate in this case. What do you say?
I don't have a problem with the social media. I just don't, with no criminal record, 29 years old, no record at this point. I understand the social media part of it. I just don't see the how to do that part of it. I'm not quite sure, given the facts and circumstances. I just don't see this as a constitutional record case.
Mr. Lewis? Before I reach a decision point, anything to add, sir?
We do believe that the council arrest or acting on will be more in this case. Although this person is arson and trying to build and burned out, and so we would like to stay away from that area. And I would give it to the judge for the state would add, of course, some type of observation.
Judge, look, I've been really hesitant to talk about that. But, we spent days here studying footage, and I'm just, this whole, she burned the building down is just a false narrative. And so she did not burn the building down. She did not put that building on fire. I'm really avoiding getting into that. That's just, the initial recommendation was $20,000, and there was no request from the state for an ankle monitor. There was no request from the state for home confinement. And I don't know when they plan on convening grand juries and when we're going to get to court. But having someone on home confinement, no record.
So, Mr. Fenling, I've heard you say that repeatedly, sir. Repeatedly. You've indicated no record. But let's take a look at the other option here, which is no bond. Let's take a look at the danger to the community. And so, if someone, and it is alleged to have set fire to a building with other people around, whether or not the building was occupied or unoccupied, that would present a danger to firefighters if they were able to get to the scene. That Wendy's is right next to a gas station. And so when you have fire right next to a gas station, that's a volatile combination. So I do not find the lack of a criminal record that persuasive. And a signature bond is denied. What I'm trying to do is fashion something that is fair, that complies with the statute, but mainly because really the only part of the statute, the way I see it, that Ms. White is likely to offend is the danger to the community. And so you see where I'm coming from, right?
Judge, I said everything I need to say. I know you. Anything I say, I have the point of conviction in return. So you've heard what I have to say. It's pointless at this juncture.
All right.
Thank you for listening.
Yes, sir. And I appreciate your advocacy as always. All right, Ms. White, here's what we're going to do. We'll set a $10,000 good bond. Conditions will be that you can be released from the custody of the Fulton County Sheriff as soon as you have an ankle monitor.
All right, 10,000. She made bond. She is out. We'll continue to track that case for you right here on Court TV.